permitting these routine stops escalated to searches of a car. The reason why this is so important to us is that it's generally conceded now that the bulk of all search and seizure cases involve cars. I estimate there's 5 to 10 a day, 5 days a week. I get them off of Lexus, and the bulk of them deal with reasonable suspicion or probable cause, but the rest involve a traffic stop, at least something more. Whether it's all in the cop's mind or not is another matter. Wayne LaFave said it now believes the largest single area search and seizure law, and I have to agree with him. A significant number, by the way, the video led to suppression of the stop, because the video literally put the lie on the cop. The court will say, I saw the video, it doesn't support what the officer said, or the officer said something on the video that indicates that the motorist wasn't free to leave after all, that the cop was going to keep fishing for consent until he got it, those kind of things. And if you're lucky, you can make more mileage out of that video. I haven't been so lucky, except a couple of times the videos actually proved the case. And in Arkansas, the Arkansas State Police have videos of about 75% of the cars. They've been planning to have it in 100%, and you always question, I do at least, on cross-examination or examination in a suppression hearing. The government has the burden to go forward. I examine cops usually on cross. Why they don't have a video in their car when everybody else does? Is it convenient that you don't have one, but you're doing essentially drug interdiction? And this is an aside, it's not even in my materials. There's one place in Arkansas where all the stops are now concentrated. They used to be over on the Oklahoma border in Crawford County, which is the first county across the state line. And there was a construction area there forever. Arkansas floated a $3 billion bond issue, rebuilt the entire interstate system. And at one time on the Highway Department's website, there were at least 19 construction areas between Fort Smith and West Memphis. And all of those were at least 4 to 8 miles long. Traffic would slow down considerably. 2 miles before the beginning, it would say, merge now, and they would use that as an excuse. They'd lay in wait. You didn't merge right away, they'd stop you. That was their traffic offense. And then they'd look for an out-of-state plate. They would admit that. But as long as it was justified by a traffic offense under Wren, that's a justified stop. And the question then becomes, what did they do to escalate the situation? Now all the stops occur in Hope County, Arkansas. The newspaper there is Courier Review. You go online and you run the names of the cops, and they admit in the newspaper articles that they look for out-of-state plates. I mean, it's great cross-examination material because the locals feed into that. They want to know about all this. The cops give them whatever it is they want for the local press, and then they don't realize that's going to come back to haunt them when a criminal defense lawyer can get it off the internet and just cross-examine them about it. This is Wayne LaFave's article. It's in the materials without footnotes. I put it in without footnotes so you couldn't claim that it wasn't fair use. But you can just type that into Westlaw or Lexus. You can't get this anywhere online for free. I checked everywhere. But just type in that citation, it'll come right up. And it's pretty long, it's about 400 footnotes. This is his discussion. Sorry. Both in urban areas and on the interstate, police are on the watch for suspicious travelers. And when a modicum of supposedly suspicious circumstances are observed, or perhaps even a hunch or pursuant to such arbitrary considerations as the color of the driver's skin, it's only a matter of time before the technical and trivial offenses produces a necessary excuse for a traffic stop. And literally, the courts will admit anybody will commit a violation sooner or later. And I think even in LaFave's article somewhere, it's either LaFave or Macklin's article, and Macklin's article is also cited in here. And you can get that for free off of the NACDL website. Just go to Champion Magazine on the NACDL website. You don't even have to be a member to get it. Just type in Macklin as a search, and then his articles will come up and you click on it. But one of those mentioned that in 1986, Rehnquist was stopped for a traffic offense at one time. And of course, he probably wasn't searched, but he certainly has a suspicious demeanor about him, particularly when he was stoned on his back painkillers. Perhaps because the offenses are so often so insignificant that driver may be told at the outset he's merely given a warning, and most of these cases involve warnings, I've noticed. But then things get ugly. And this is the hit part down at the bottom about the dog. As a part of the routine of criminal history, an outstanding warrants record check is run on the driver and the passengers, closely questioned about their identities, the reason for their travels, their intended destinations. Get them out of the car and ask them different questions, or ask them questions, and then compare the answers. We've all heard that for the last 25 years. And the like, and may be quizzed about whether they have drugs on their person or in the vehicle. The driver may be induced to submit to a full search of the vehicle. Or a drug-sniffing dog, the dog may appear on the scene and do his thing. Well, this was written just a couple of years ago, and he says, do his thing. We haven't heard that since the 70s. And I figure LaFave is 60 or 76 years old when he graduated from college, which is 1957. Keep in mind Carey versus Ohio, because that, to me, is the key to it. Carey, by the way, is 40 years old on Tuesday, June 10th, 1968. And this is the touchstone of every reasonable suspicion case there is. And this key phrase must be strictly tied to and justified by the circumstances that rendered its initiation permissible. Now, ironically, the Supreme Court has never said that a traffic stop is governed by Terry. It's applied it in dicta in Berkmer versus McCarty that said Miranda doesn't apply to a traffic stop because it's an investigative detention. But it's based on the probable cause for the traffic offense. Or swerving on the road, maybe reasonable suspicion. You cross the fog line, that's a violation of the law, but they don't give you warnings. They pull you over to see if you're impaired or you're falling asleep. That's the usual justification for that stop.